Everyone, welcome to the North Carolina Court of Appeals. We're going to be starting in just a few minutes. If you have not already, please silence your cell phones. If you need to leave the courtroom during the argument, please exit through the rear door and then return through the rear door. And with that, I think we are ready to go. We're ready when you are. All rise. The Honorables, the presiding judges of the North Carolina Court of Appeals. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. We have one case on the docket today, Stein versus Hall et al. The panel this morning, to my right is Judge Valerie Zachary. To my left is Judge Allegra Collins. Our clerk of court today is Jean Soar, and our court marshal is Tom Salou. We have multiple appellants and appellees in this case, and counsel has advised the court on the way that it wishes to proceed. Do we need to clarify anything further on that at this time? We particularly like to welcome the large number of law students and interns that are with us today in court. I know the weather's bad and cold, and we appreciate your time in coming out and being with us today. Are there any preliminary matters to come before the court before we get started? Okay, all right. At this time, based upon the parties' agreement, we will hear from the appellant. Good morning.
Good morning, Your Honors. May it please the court, my name is Martin Warp of Nelson Mullins, and with Mr. Matthew Tilley of Womble Bond, we represent the legislative defendants in this case. Given the nature of the appellant-appellee situation, I'll reserve 13 minutes for a rebuttal and use that to address the appellee's argument.
Okay.
The question before this court is whether the General Assembly can create political qualifications for judicial vacancy appointees. And the answer is yes. And in that answer, we are guided by two principles. First, the specific language used in Articles 2, 3, and 4 confirms that the legislature, not the executive or judicial branches, wields plenary power. And because of that, this is the second principle, we will require a constitutional limitation on the General Assembly to be explicit in the text of the Constitution and demonstrated beyond a reasonable doubt. We are the appellant here today, but we do not necessarily have the burden. 163-9 is constitutional unless the governor can show an express prohibition in the Constitution against it. The governor argues that the Article 4, Section 19, in particular, the first part of that section, provides that limitation, and it does not. Article 4 covers 6 different offices in the judicial branch. The Supreme Court, under Section 6, says nothing on vacancy. Section 7 on the Court of Appeals says nothing on vacancy. And Section 9 on the Superior Court says nothing on vacancy. But there are vacancy appointments listed in Section 9 for Superior Court clerks, in Section 10 for the district court judges, and also for the magistrates. So you come to Section 19, and the first part of that phrase is, unless otherwise provided for in this article, the governor makes the appointees.
Wait, let's just say that word for word so we know what the text is, since we're being textual. What does that say?
It says, read it word for word. Unless otherwise provided in this article, all vacancies occurring in the offices provided for by this article shall be filled by appointment of the governor.
And it's your contention that shall be filled by the appointment of the governor is not explicit enough that it shall be filled by the appointment of the governor?
Appointment of the governor would apply to 3 different offices, but appointment of the governor is what occurs here. He's the only one with the power to take a potential nominee and make them the appointee. So we do believe that the governor is making the appointment here under the amendments to 163-9.
Doesn't the statute explicitly provide that the governor would make the appointment?
It does. The governor makes the appointment. No one else does that. It's not given to, as you'll see later in the argument, another executive branch official. It is only the governor because that's what the Constitution says. But there is no language there that suggests that how the governor is to choose among his nominees to make the appointee. There's nothing in the Constitution about that. And that's where you have to find that unless there is an explicit limitation on an act of the General Assembly, then the General Assembly's act would be constitutional.
Doesn't the Constitution provide some explicit limitations, such as that the appointee must have a law degree?
It does, and that's in Article 4. And you can see from that explicit qualification that also applies to elected members of the court as well. So when you have elected members, they have to be have a law degree. Appointees must also have a law degree. But that is in Article 4, and the reason why that was added, I think, is because you have a section about qualifications for office of elected officials that says, to your point, Judge Zachary, it notes that, every qualified voter in North Carolina who is 21 years of age, except as in this Constitution disqualified, shall be eligible for election by the people to office. So unless you had the law degree requirement in the Constitution, then someone could be elected without a law degree if that were just a statute. Because you can only, except as in this Constitution, be disqualified for elective office. But the court has not said the same thing about appointive office. So appointees are different, and appointees do not have that same express prohibition that you see where the General Assembly could not add additional disqualifications to elective office.
Let me ask you this. If the statute, the amendment had said that the governor shall appoint only from members of the Wake County Bar, would that be upheld?
I think that potentially could be upheld, Your Honor, because the governor in that situation still has a choice. And he has a list of nominees that he can choose from and can make that choice. And so he's still the only one in that scenario that would take any member of the Wake County Bar and make them an appointive official. And the benefit, I think, or the difference between being an elected official and appointed official is because we elect our judges, we value the people's opinion on that election. So the appointive measures are made very small.
So what
less
about
than 2 years.
any lawyer who lives on Pony Run Drive?
Sorry, what?
Any lawyer who lives on Pony Run Drive, could the legislature put that caveat in there?
Well, I think that would certainly be unwise, but it might be possible. The difference being, I think you have to know how many lawyers live on Pony Drive.
There's at least one.
At least one, but there probably should be more than one. Because I think if you had a statute that actually, for the lack of a better word, actually made the appointment, then you're taking the word appointment out of the Constitution and giving it to someone else.
Sure,
So I
so
think
if there are two, then that's all the governor needs to be able to choose from, is just two?
I think he has to constitutionally have a choice. I think it's a policy decision as to how wide that choice be it 3, 2, 1,000, or unlimited. That's a decision for the legislature on the policy behind that, but the Constitution requires that he be able to have a choice so that he can take a nominee and make them appointee.
So what pool, what limitations on the pool of possible appointees who otherwise meet the other qualifications are constitutionally allowed? Any?
If they otherwise meet those qualifications, I think as long as there is a choice involved, then that limitation would be okay.
And the choice could be down to as few as 2?
It could be down to 2. I think that would be potentially unwise, but constitutionally speaking, there's still 2 nominees, and he would have to make a choice between those. He still retains the power to make the nominee an appointee.
In terms of the district court judge's appointment, the statute provides a far different method for appointing district court judge vacancies, correct?
It does.
And those nominees come from the local bars, right?
They do, yes.
And I think now it's up to 5 members. So the local bar is a sanctioned member of a reference. They are part of the statute, correct?
I believe that's correct, Your Honor.
So what effect, if any, is the fact that the person or body that's making the appointment has no sanction or no statutory basis within the appointment?
I think that's okay, Your Honor. As long as there is, again, you're talking about a policy reference to say that, we probably don't want the dog catchers union making appointments to the court, but at the same time, that's a policy choice. The Constitution requires only that the governor make the appointment. And so.
But can I just, it requires that the seat be filled by the appointment, not just the governor appoint somebody for some random reason. Filled. Talk about that word filled.
Well, I think the word filled, you can see, is a person who takes the office is filled by that appointment. In, I think it was the Brandon case, the court looked at a situation where the legislature passed a statute to actually name individuals to the Court of Appeals in an expansion context. And the court struck that down as unconstitutional because once the office is created, it is vacant until it is filled. And so the vacancy
filled
here—
by, in that case, an election, correct?
Well, yes, that was the statute was designed for that, but the issue was that the General Assembly was trying to basically fill the vacancy with a named individual, and so you had that shift between the governor making that vacancy appointment to the legislature. That's what the court did.
Right. So there's a shift in who is actually doing the filling, right?
There's a person?
A shift between who is actually doing the filling of that.
Yes.
And my point is that the appointment isn't an appointment unless you have the power to fill the position with your appointment.
I agree. I think that's the nature of the appointment is the sort of, if you have an appointment obligation or power, then you have ability to make a choice. But I think the question is, how broad is that choice? And the Constitution does not speak to that. So I think if the legislature tried to give the appointment power, the obligation to anyone other than the governor, that would be unconstitutional. But it's not necessarily unconstitutional to have a situation where a statute comes in and fills a gap that says, here is the arrangement for the list of nominees. We couldn't do that for an election, right? We couldn't do that for elective office because the Constitution says all of those disqualifications must be in the Constitution. But we can do that for an appointive office, someone who's serving to fill a vacancy and who's potentially going to run for election themselves or bow out and have somebody else run. And when we do have partisan elections, there is some benefit to having to have parties involved in selecting those choices and giving those to the governor to decide among who will fill that vacancy appointment.
Going back to the Court of Appeals expansion case that we talked about earlier, the legislature had attempted to create a 4-year term on new appointees, correct?
Yes.
And the court held that you must stand at the next general election, and they reduced those 4 years to 2 years. How, if that method of extending terms is not constitutional beyond the next general election, how would designating the source of the appointment not also be unconstitutional?
Well, I think in that sense, the reason why that was unconstitutional was the Constitution is very specific about when that next election needs to be. If you're appointed within, I think it reads, yes.
But those positions had never been created before. It wasn't like a vacancy occurred. It was a creation for additional seats.
Right. The court held that when the legislation created those 3 additional seats, that you couldn't create the office and fill it at the same time. That the creation of the office created a vacancy situation for which there needed to be an appointment. So the legislation itself couldn't say that, Judges Zachary, Collins, and Tyson fill those seats, but if the governor appointed those 3 individuals, then they could fill those seats.
Well, that was the case. The governor did appoint.
Yes, but I think that was, the idea was that they were, the issue was, again, that there was a situation of extending the term and that the governor didn't have the complete power to appoint those vacancies in that way. The legislation did that a little bit.
Well, now, the 3-judge court below, and I know this is probably a de novo standard review.
Yes.
You have the burden because the lower court's ruling is presumed to be correct. Do you agree with that?
Well, I agree with that being the role of the appellant, but because it's a de novo review, then this court decides in the first instance what the proper interpretation of the Constitution is, and that is in a sense where the lower court got it wrong. So I think we are the appellant and on this issue, but the issue is one of de novo review where the court can substitute its judgment for the court below, and we would say that that would be proper in reversing it here.
With the Martin case that the Supreme Court decided in the 1990s speaks to district court appointments. Is that correct?
It does in part, yes.
Is that applicable here?
It is. I think it provides the framework for how you can see the exercise of plenary power as just one additional step from that Baker v. Martin opinion. In Baker v. Martin, the court looked at district court judges and found that the General Assembly could add qualifications for appointees. And in fact, they added a political qualification for that appointee through that statute, which was that the incoming nominee must be the same political party as the outgoing judge. But the court noted that that section of disqualifications, Article 5, Section 8, was more of a ceiling, and I mean, it's more a floor and not a ceiling. The General Assembly could add disqualifications to appointees. And the court did look at the fact that the district court position there in this Constitution says as prescribed by law. But here, so I think that gets you far enough down the road, and here we have a situation where we don't have a prescribed, the General Assembly doesn't have a prescribed requirement to act on vacancies, on the qualification of vacancy appointees, but they have the plenary power to act unless they're otherwise, unless there's an explicit bar in the Constitution to that action.
Didn't the court in Baker emphasize that?
They did. In fact, they applied a situation where you had a, I get the Latin wrong, but it's the expression of one does not exclude the other. And so I think you've got a situation where they said simply because you might have a situation where the General Assembly is prescribed something to do, a requirement to act, doesn't mean that the absence of somewhere else is a prohibition on them acting. They can, but it's not prohibited. You saw the same thing in the Cooper, what we call Cooper confirmation opinion, where the court looked at the advice and consent of the Senate on Cooper's nominees for the secretaries of the various departments. And in that case, the court said, again, just because it's explicitly provided somewhere in the Constitution, we don't read that to mean a prohibition where it's not. So I think if you stack the Baker opinion, you don't have to go very much further than the interpretation of the Constitution to arrive at the point where there is no explicit check on this, so it needs to be constitutional.
If the General Assembly had provided that the nominees would be provided by, let's say, the mayor of Charlotte, or let's say even worse, that provided by the person the governor defeated in the general election. You see any difference with that?
Are they providing more than one?
Yes, two.
Just two? I still think that would be okay.
Even the person they defeated?
Even the person they defeated. I do not think that to be a very wise move or what the legislature would pass, but constitutionally speaking, there is an opportunity for choice there. And that's what the Constitution requires.
It isn't really a choice.
It is. It's not a choice where there's just one. That would be similar to the statutory provision where the vacancy appointees are done by the governor for legislative appointees, where the legislature says this is the one you're going to appoint. And the idea behind that, and probably the idea behind the Constitution and the governor making these appointments, is because the governor is a full-time employee. The legislature is part-time, and they're not there all the time to answer the calls for vacancy appointments. So I think in the history of that, that's why the governor was always given those appointments, but because they're the ones that are there, can answer the call in the night.
Is there anywhere in any prohibition in our Constitution for the General Assembly to make policy decisions that some people might consider crazy?
Well, that's their right as the legislature to make this court and the Supreme Court has held that they are the policy-making branch. And our courts have held before that this court and the courts in general do not judge the wisdom of a particular act, but just whether it's constitutional or not. And the General Assembly has the ability and probably the need to experiment with certain things that may or may not work. And the benefit of having this as a statute means that a different General Assembly, a different session, a different group of people down the road may consider this later to be an unwise policy and change that through a majority act.
Well, don't the people of the state have a ready response if they think that this is an unwise act on the part of the General Assembly?
They do. The General Assembly is elected every 2 years, and I have a feeling if they made a law that said that only those judges appointed by the defendant or by the defeated governor or someone on an address would probably not look well to those people who voted for the majority in that, and I'm sure they would have to answer to their constituents for it.
So other than there must be at least two, is there any other limitation?
On appointees?
As far as, of course, they have a law license and their age.
As long as they, no, I don't think so. I mean, if they're meeting the Article 4 requirements of age and law license, which would require both appointed and elected officials, they also have to meet the other Article 5, 8 section, which I believe there's one about residency for elected officials. That would not necessarily apply to an appointed official. So potentially the governor could appoint a judge who does not live in North Carolina, but has a North Carolina law license, somebody from South Carolina perhaps. But they could not appoint a felon. That's in the Constitution as a disqualification for office for both appointees and elected officials.
You want to reserve the rest of your time?
I will, Your Honor. Thank you.
Thank you. Hear from the appellee. And I understand that you will also, when you complete the argument on the vacancy, you will go ahead and make your argument on the Utilities Commission. Is that correct?
That's correct, Your Honor.
Good morning.
May it please the court, Dan Smith, on behalf of Governor Stein. I'm joined today by my law partner, Eric Fletcher, and I am going to start with the judicial vacancies issues that was just argued by Mr. Wharf. So at issue before the court is a legislative attempt to expand legislative powers beyond what the Constitution permits. So this is not a question of legislative policy, it's a question of constitutional balance of powers and what the people have set forth in the plain constitutional text. Now, to meet this analysis or to complete this analysis, we look to the text, the history, and the precedent. When we look at those three points of analysis, the judicial vacancy appointment provision challenged here unconstitutionally disrupts the balance of power set forth in the plain language of our Constitution. It attempts to change by mere statute the governor's constitutional power of appointment to fill vacant judgeships until an election can be held.
How do you respond to Mr. Wharf's argument that there are no limitations, that if you're not a felon, you're a member of the bar, you have a law license, possibly be a resident of the state, maybe not, that's sufficient?
So that's an argument that was raised in the reply brief, relying on some text in Baker v. Martin, where the Supreme Court said the list of disqualifications is not, potentially, I believe is the phrase, potentially not exclusive. That's a 1991 decision. And if you'll excuse the pun, we need to look a little bit more to 1992, Moore v. Knightdale Board of Elections. That case is about disqualifications. There it was a resign to run statute. And the Supreme Court went through Article 6, Section 6, and Article 6, Section 8, those disqualification provisions. And it, in fact, concluded that those provisions are exclusive. In fact, the Ortho Nubi Treatise, also first published in 1992, in the annotations to 6.8, and I'll read for you, the list of disqualifications for office in the present section is exclusive. The General Assembly may not add to it by statute, citing Moore v. Knightdale Board of Education, or excuse me, Board of Elections. And so that argument, you know, it's in the reply brief. We don't have a sir reply. I wasn't going to try that. But the point is, it's not well thought through. The other problem with that argument is trying to treat the appointed judgeship as an appointive office. Now, appointive office is a constitutional term of art that shows up in the dual office holding provision. I would submit, and I believe I'm right, that's why I'm saying it, that the Court of Appeals judgeships, whether elected or appointed, are elective offices. Otherwise, it would be constitutionally possible for someone to be an appointed judge of the Court of Appeals, and because you can hold two appointive offices at the same time, a justice of the North Carolina Supreme Court. That doesn't make any sense constitutionally. And so for that reason, we have to treat Court of Appeals judgeships and Supreme Court justiceships as elective offices. And under Moore v. Nightdale Board of Elections, sorry, I represent a lot of Board of Ed, so Nightdale Board of Elections, in that case, we know that you can't add another qualification.
So their argument, as I read it, is they're not taking away the governor's power to appoint. They're just sending in a pool of applicants from which the governor should choose which of those he or she would like to appoint.
But that is the power of appointment. The plain text of the Constitution says, unless otherwise provided in this Article 4, all vacancies occurring in the offices shall, and that's mandatory language, be filled by appointment of the governor. So what the legislative defendants are arguing is that that word appointment gives them room to put all these qualifications on. But as we just discussed, you can't add qualifications. And if we're going to do a textual analysis, if you look at the last...
Can you add disqualifications?
Qualifications or disqualifications, if you look at the last sentence...
No, they're different. Qualifications means you are age, member of the bar. Disqualification would be a felon, probably a non-resident.
Well, but it's a positive negative. So you could phrase the qualification not being a felon. You just add the word not, and a disqualification becomes a qualification. So for that reason, whether we call it a qualification, a limitation, a restraint, the legislature is trying to introduce itself in here. But
why is it your argument then, why would it not apply to the appointment of district court judges from a predetermined list?
Okay, the reason it's permissible, and this is what Baker takes us through, the Supreme Court in Baker, Article 4, Section 10, in two places, envisions a legislative role. So as a matter of the balance of powers of the Constitution, the legislature has a place. And I'll read for you, district court judges elected in a manner prescribed by law. That's code for enact a statute. And then in terms of vacancies, vacancies in the office of district judge shall be filled for the unexpired term in a manner prescribed by law. Legislative role.
But are legislative acts valid unless provided for in the Constitution or unless prohibited by?
Legislative acts are presumed constitutional unless there is a constitutional limitation. Here, the constitutional limitation comes from Article 4, Section 19, which says, unless it's provided for in this article of the Constitution, the governor appoints. Chief Justice Newby and Professor Orth in their treatise characterize this as an unfettered power of appointment.
Couldn't it have meant to date unfettered?
Has it been to date unfettered?
Couldn't they have meant to date unfettered?
Well,
rather than, constitutionally unfettered.
Well, I think that's an interesting question because the fact that since 1868, so more than 150 years, the people of North Carolina and the courts have kind of liquidated the meaning of that phrase. In the 1868 Constitution, then it was Article 4, Section 31, after 1875, Article 4, Section 25, unless otherwise provided for in this article. In the 1895 decision of Ewart v. Jones, the Supreme Court said, this means in the Constitution. When the Court of Appeals was added, when the judicial article was rewritten in 1962, when there was a change from 30 to 60 days in 1985, all of that, through that, the governor's unfettered power remained. In terms of history, which informs the constitutional analysis.
But wasn't the governor, weren't the governor and the judiciary of the same party at that point?
In which point? In Baker v.
When
Mark?
the Court of Appeals was created.
It may have been, but what's interesting.
So that to me that would make a difference and how this was being viewed.
I'm not sure it does, Your Honor, because our Constitution thankfully never mentions partisanship and never mentions political parties. So a political party has no constitutional status. And what the amendment to 163-9, which had, aside from Senate Bill 382, it has universally provided since it was enacted in '67 when modern election law came into play, or that chapter was enacted, it has always recognized the governor's constitutional power. Prior to the 1960s, the general statutes or the statutory provisions also just pointed to the Constitution.
Let me ask you this. There have been a lot of efforts in the years to create what's called merit commissions, composed of various bar associations or groups to make recommendations for appointments. And there are a lot of states that have that does limit the power of the governor to the recommendations from the Merit Commission. How is this any different than that?
So that type of proposal would require a constitutional amendment. So in 2018, the legislature proposed a constitutional amendment to the people.
And it was rejected.
And it was rejected. But notably, that constitutional amendment did the exact same thing that the challenge statute does here. It provided nominees to the governor, and the governor made a selection. In that session law, and you know, it's hard to get the legislature to speak. We can't ask their general counsel or their counsel here to speak for the whole legislature. The way they do it is through session laws. And in that 2018 session law, proposing the constitutional amendment to the people, what they did was say that we are changing from the governor's, quote, sole appointment power to a process where we have nominees and a selection from nominees.
So is your challenge more to who's providing the list, or is it that plus that it must be the same political party as the departing judge? Are you challenging both or one?
We are challenging any limitation on the governor's power of appointment.
It's not expressly in the Constitution.
That's not expressly in the Constitution. So the Constitution provides the law license requirement, and that was added in 1979 by a constitutional amendment. It has the judicial retirement piece, and it has the provisions in Article 6 related to disqualification.
Could the governor, under your analysis, appoint a member of the North Carolina Bar who does not live in the state?
I believe that that's within Article 6. It's an Article 6 requirement.
So that's a limitation.
Well, the question is, would it ever get tested? It's kind of like some of the hypotheticals, you know, if was it the dog walkers, the dog catchers union, if they were making the
The mayor of Charlotte.
Yeah, or the mayor of Charlotte. I don't know that because of norms, whether the governor would ever do that. There are plenty of qualified attorneys. But our position is 163-9 should simply restate, as it did from the 60s until Senate Bill 382, should restate that the governor fills these positions.
Unfettered.
Unfettered.
Within the constitutional
Within the constitutional limitations. So the governor could not, for example, appoint someone without a bar license. That's a constitutional requirement that's provided for in Article 4.
If the list of nominees would be limited to an immutable characteristic, sex, race, national creed, the prohibited classes, would that be subject to a challenge? You must choose this sex or this race.
That, I believe, would fail under the United States Constitution, as well as the kind of analogous provisions of the North Carolina Constitution.
So you would include then immutable characteristics, choice among those as a disqualification, correct?
I would say that a statute, I think I'm answering a different question. A statutory provision that says you must appoint a white male above the age of 60 to the Court of Appeals, that statute would violate other constitutional provisions.
So that would remove the governor's authority to do that, correct?
That
Or be
statute-
limited to that specific, those characteristics?
So that hypothetical statute would have two problems. It would violate anti-discrimination provisions of the U.S. and North Carolina Constitution. It would also be a restriction on the governor's unfettered power of appointment that's not in Article 4.
So it would violate both in your view?
It would violate both. And to be fair, I've not done the separate U.S. and North Carolina constitutional analysis for that type of discrimination.
So
I'm reasonably confident.
we agree there are limitations.
There are limitations provided for in Article 4, Section 19, and Article 4 broadly. The limitation, the way I would look at it is the Constitution as a structural matter. The people have made a decision that they want the governor, as recently as 2018, 2.4 million people to 1.2. More than 2/3 of North Carolina voters said, we want the governor to have sole appointment power, to continue to have the same power he's had for 150 years.
And those appointments, the type of person who can be appointed is also in the Constitution.
It's also in the Constitution.
And those are the limitations or the restrictions.
Those are the limitations, the restrictions, the qualifications, the conditions. They have to be in the Constitution.
We don't want to limit your time on the Utilities Commission, so.
Well, I would like to make a few more points about judicial vacancies. First, one thing that I'm not sure I actually got it out because the questioning has been so excellent, but Article 4, Section 19, if you look at the last line of it, it actually already speaks to qualifications. If any person elected or appointed to any of these offices shall fail to qualify, the office shall be appointed to, held, and filled as provided in case of vacancies occurring therein. So Article 4, Section 19, as we've been discussing, also references qualifications. And it's again pointing to the Article 4 qualifications. The other piece that I want to touch upon is the idea, a lot of legislative defendants' argument is this idea that appointment doesn't mean unfettered. But we can look to the Supreme Court's opinion in the Cooper confirmation case there that upheld Senate confirmation of the governor's cabinet secretaries. There, our Supreme Court talked about what the power of appointment means. And there in Cooper 1, what the Supreme Court said, this is 808 and 801 in the North Carolina Reporter, the governor may select his nominees from a virtually unlimited pool of qualified people. That's what appointment is. The ultimate appointee will be a person that the governor alone has selected. Under the challenge statute here, which the trial court rightly enjoined and held unconstitutional, the ultimate appointee, if this is allowed to take effect, will be someone that partisan insiders have chosen. And that's not something that the people want. The people were presented with this choice 7 years ago, and they said, no, we want the governor to have the sole appointment power.
Explain to me how the difference between allowing a group of individuals to go to the governor from which he or she can appoint versus allowing the governor to choose somebody that then has to go through confirmation. It seems like you're ending up in the same place, and how was the cabinet secretary's case different?
The cabinet secretary case is different because there the analysis is under the separation of powers clause of the Constitution, the governor's executive power and the governor's duty of faithful execution. In that case, cabinet secretaries and cabinet departments are created by statute. So they owe their existence to legislative creation. Even then, Chief Justice Martin was clear to say that they are some of the governor's closest deputies, and the governor has to have significant control over them. So in that case, and this is where Chief Justice Martin and a unanimous Supreme Court talked about what appointment meant, he's saying when the governor alone makes the choice, that's a strong appointment power. There's just this slight issue of having an up or down choice by the legislature. When the governor can remove that person at will, something that doesn't apply to judges, thankfully, that the governor has significant power. So it was through the appointment, supervision, and removal lens.
I want to go back to a minute between the source of the appointment and the fact of the replacement, the appointee being of the same political party. Those are two different things. You agree with that?
The source of the appointment is the governor.
No, the source of the nomination.
The source of the nomination is a political party, yes.
Right, or the executive director of that party.
Yes.
Do you challenge the fact that that particular source of the nomination is not a governmental body or official?
No, Your Honor. It could be a governmental body. It could be the Court of Appeals sitting en banc. It could be a merit commission. If you want to make that type of change, the people need to make that change in their constitution.
Where the Chief Justice decides who is the senior resident Superior Court judges and who the Chief District Court judges are. That's not a governmental appointment there. That is a governmental actor. I just want to see, does it make any difference to you, for example, district court judge nominations come from the bar, which is a recognized governmental sanctioned group. Is there a problem with the fact that the source of the nomination is a private party?
The constitutional problem here is that the legislature is getting involved where there's a constitutional framework, a mandatory constitutional framework that gives them no rule.
So if the statute said, okay, Governor, choose anybody you want, but the successor must be the same political party as the person who is leaving office.
And that's what happened in Baker v. Martin. And there, what the court went through, it went through first just because
And they upheld that, correct?
They upheld that. They went first through Article 6, and then they came to the arguments that Mr. Martin or Mr. Baker, I've forgotten which, the candidate was making, the Republican candidate saying, I should be able. And the court looked at Section 10 and said, Article 4, Section 10, the fact that it says, vacancies shall be filled for the unexpired term in a manner prescribed by law. That means there's a role for the General Assembly to play. And Baker actually says, and I'm going to mess up the quote, but something like, Article 4, Section 19 alone does not answer this question. But when we look at, as Mr. Worf, I believe, said at the beginning of his argument, as to Supreme Court justices and Court of Appeals judges, there's no such language like that. And Judge Tyson, to your question about the Chief Justice, that assignment authority is structurally in the Constitution. Article 4, Section 11, the Chief Justice of the Supreme Court, acting in accordance with rules of the Supreme Court, shall make assignments of judges of the Superior Court and may transfer district judges, so on and so forth. So
those are assignments for cases. That's not necessarily, does that apply to who's going to be the senior resident or who's going to be the chief district court judge? You think?
I believe some of that, and that gets a little bit beyond what I've analyzed. I think the fundamental point, and then I would like to get to the Utilities Commission, the fundamental point I'd make is that the constitutional, judges are important. Courts are important. Impartiality is important. And so Article 4 of our Constitution is very precise and very clear and does not leave room for the legislature, because otherwise all of the important things that courts do are drawn into question. So on that point, what I would say is that this court should affirm that the judicial vacancies provision is unconstitutional. Yes, and Mr. Fletcher is earning his keep. In Article 4, Section 10, when more than one district judge is authorized and elected for a district, Chief Justice will designate the Chief District Judge.
So that is constitutional.
It is constitutional. I would be surprised if it wasn't. All right, so quickly to the Building Code Council and the Utilities Commission. Obviously, the Stein what we call the Stein Commission's opinion came down on October 15th. As we've put in our supplemental brief, I think that captures our position fairly well. We think that as to the Building Code Council, there's an NRA civil penalty kind of restriction. As to the Building Code Council and the Residential Code Council, there's one ground, the idea from, or the principle from Cooper 1, the Board of Elections case, that the governor has to be able, within a reasonable period of time, to take care that the laws are faithfully executed. With both Building Code and Residential Code Council, the governor is reduced to an executive veto. I mean, consider that. It's the equivalent of the position he has as to the legislature and what the court has authorized. But I'll leave it at that. With respect to the Utilities Commission, just very quickly, we know that there's not a political question defense here. This is justiciable. We know that it is executive. We would urge the court to find that the Utilities Commission is unconstitutional on two grounds. We view the treasurer's appointment as functionally, and under McCrory and its progeny, it's a functional analysis. We believe that treasurer's appointment is legislative. And so it's the legislature, directly through its two direct appointments and indirectly through the treasurer, that controls the work of the Utilities Commission as a constitutional matter. If you look at McCrory and its progeny, what does the challenge statute allow? And here the challenge statute allows the legislature to control the execution of the law. The other grounds that this court should use to reverse the trial court is that the major purpose, the constitutional role of the treasurer, does not include utilities regulation. So it's a kind of, to our earlier discussion, Judge Tice, about qualifications, disqualifications. It's almost as a constitutional matter, the treasurer is not qualified to take on that role.
Well, there's been several precedents from this court and from the Supreme Court that's treated the Utilities Commission as an independent rulemaking quasi-judicial body, not like a cabinet position. So doesn't that undermine your argument that it's not within the treasurer's portfolio? The Utilities Commission would not be within his or her range of interest.
So whenever we talk about a quasi-judicial or quasi-legislative body, that's Administrative Law 101. That means it's an executive body. And in fact, going back to Article 4.
Well, and the treasurer is a member of the Council of State in the executive branch.
And the treasurer has all of his powers thanks to the General Assembly, and has, in his brief, said the General Assembly has unfettered power to move this appointment.
If the appointment to the Utilities Commission had been made by the Attorney General as opposed to the treasurer, would you have the same objection?
We would have the same objection, Your Honor. All right.
So the
That it's
political,
functionally legislative?
That it's functionally legislative because the legislature can keep moving that appointment.
Okay.
All right, I'll reserve the remainder of my time for rebuttal.
1 minute. You have any questions? Give me a question. No, well, you want to? Thank you, sir.
Thank you.
Hear rebuttal, right, on the, or the appellee on this issue.
Yes, Your Honor. I will respond as the appellee and handle the rebuttal on the judicial vacancy piece together. Starting at least with the appellee issue, just briefly, Your Honor, I'd like to acknowledge Mr. Craig Shower is representing the treasurer and has graciously yielded his appointed time back to me so that we can follow through. But I want to say one thing about the appointment power, and it goes actually to both issues, both the judicial vacancy piece and the treasurer. The court, our Supreme Court, this Court of Appeals has said several times that the ability to appoint someone is not an inherently executive role. So the fact that appointments could be given in some cases to the Chief Justice is an area that's okay because it's not a constitutional power of the executive to a sole power of the executive to appoint someone. So I think even in the situation of judicial vacancy, having a private party suggest a pool of nominees is even below that level and would not be, does not trigger any review.
How do you respond to the your colleague's suggestion or argument that the voters had the choice to adopt a non-government or a governor system of nominees and rejected it in a constitutional amendment?
They did, and I think there's a couple of things to note about that. First of all, unlike passing a constitutional amendment, the rejection of a constitutional amendment is hard to read in why a particular amendment was rejected. We know that it was. And in fact, here, this constitutional amendment, as Mr. Smith potentially alluded to, it might have taken a constitutional amendment to have the legislature give the nominees to the governor, in part because that could trigger at least some separation of powers analysis, where you have a potential for the legislature to execute something as opposed to just merely passing the law. But I think the other potential would be the fact that the people are jealously guard their right to elect the judges, and that constitutional amendment moved the appointee, as we talked about before, from 2 years to up to 4 years. And in matter of fact, that was mentioned in the report on the constitutional amendment to the people by the Secretary of State, the Attorney General, and Mr. Coble of the Legislative Affairs Division. So I think there are a number of reasons why that might have been rejected, but none of those are really the case here because we have the governor making the appointment, and we simply have a statute, not a constitutional amendment. We have a statute that selects that pool of applicants to be given to him by private political parties. Or if the elected official was an unaffiliated judge or justice, then the governor would have the full panoply of ability to choose to replace that person with another unaffiliated justice or even a political affiliated person, Democrat, Republican, Libertarian, etc.
Let me ask you that then. So let's say that the departing judge is unaffiliated. What would be the under the amendment that you're arguing? What would be the source of the nominee as well as any qualifications of the nominee?
The source, I guess the source of the applicant pool, for lack of a better word, would be that the governor could pick amongst how they do essentially right now. I mean, we don't know exactly how the governor makes the appointment. That's all done, behind closed doors with them, maybe through interviews or something else. So I think they could probably take that same process. Interestingly, I disagree with Mr. Smith about one thing. If there is no legislative act suggesting how the governor chooses their applicants, I think the governor themselves could come up with a merit commission and take those nominees and use their.
Well, that was done under the Purdue administration.
Yes, it was. That was passed under the Purdue administration, and I believe McCrory did not follow that same idea. Both of those would have been fine. Where I think Mr. Smith's argument breaks down is really the trying to put this plenary defense dome around Article 4 and saying that Article 4 does not recognize any plenary power of the General Assembly to act. And that's through that phrase of unless otherwise provided in this article. But as we've talked about earlier, that is really a grammatical phrase to show that there's a difference between appointments that have no vacancies listed in them and then Section 19. It's this sort of residual clause that you might find in a will or something else, says anything left, this is how you deal with it. Where I think you can see that that's not a prohibition is when you look even at Article 4, Section 1, when it says the General Assembly shall have no power to deprive the Judicial Department of any power or jurisdiction. That's pretty expressed and clear that the General Assembly could not pass an act to alter the jurisdiction of a particular court. And you look also at Article 3, Section 5, 6 on the governor's role in clemency. We talked about in our brief that I do not believe a legislative act could condition or qualify the use of clemency power because the Constitution says, upon such conditions as he may think proper, he or she, but upon those conditions. So could the General Assembly come in and add conditions? Likely not, because the Constitution says, upon those conditions as they may think proper. The other aspect, I'm not familiar with the Moore v. Board of Elections case, but I would be willing to bet that that dealt with the elective disqualifications for elective office, which, as we talked about earlier, is baked into the Constitution and cannot be changed.
Do you think Baker versus Martin, as it relates to upholding the same political party as the party judge, is binding in this case?
Well, Your Honor, I would love to agree. Well, I'd love to say that it is binding. I think it is highly persuasive. It gets you about 85% of the way there, because you do have the binding aspect that a political affiliation qualification or disqualification is okay under the Constitution. Where I think you have a slight difference is the court was able to go to that prescribed power by law. And here, we're not looking at a prescribed power by law. We're looking at a plenary power, which constitutionally is the same thing. It's the same thing, but I would think that someone may argue to distinguish those cases in that way. But it would not be very much of a distinction in my mind. The last couple of points, well, I would like to say in closing, I don't think that there's any daylight between this court's recent opinion and the Building Code Council. And I also think that when you look at the ability to appoint someone, the treasurer has just as much ability to appoint a person to run a utilities commission or help run that than as the governor. They're both executive officials. And, Your Honor, we would request that the court reverse the trial court's opinion as to judicial vacancies, entering summary judgment for the appellant on that issue, the legislative defendants, and affirm as to the appellees on Utilities Commission and the Building Code Council. Thank you, Your Honor.
Thank you. The court is going to grant an additional 10 minutes to each side for further questions on the Utilities Commission appointment.
Okay,
So if you would like to continue, or if you'd like the other, since you are the appellee in that grounds, if you would like to defer, or if you would like to continue, I'm going to leave that to you.
Your Honor, I would elect to defer to Mr. Smith to make any additional arguments that he would like in his 10 minutes, and we will respond to those. And likely either I or Mr. Schauer will respond to those. If there are no additional questions on judicial vacancies, though, I will stand down.
And going just to put a cap on the Building Code Commission, you would argue that the lower court was correct in that ruling?
We would argue that they were incorrect. in holding, I'm sorry, yes, I get confused. Yes, we won that, sorry. Yes.
And you do recognize the governor has reserved the right of appeal both in the earlier case and any decision of this case as well,
We do.
as it relates to that matter.
As it relates to that matter, and I believe they have reserved other issues for if there's potential appeal to the Supreme Court, and we would reserve the idea, at least expressed here, that there are issues and challenges that we would make to the Supreme Court because there's certain opinions that we believe might be able to be changed by them.
Okay, thank you, sir.
Thank you, Your Honor.
Mr. Smith, we'll, and again, we're going to be focused on the Utilities Commission. So I recognize Judge Collins for a question.
And on to the Utilities Commission.
Yeah, I don't think we heard much from you on it, so here we go.
So the Utilities Commission issue is, and I think it's important to separate it from the judicial vacancies. It's a constitutional analysis under the McCrory framework, where we look at whether the governor has enough control to fulfill his duties. He is vested with the executive power of the state, and he has the duty to ensure the faithful execution of the laws.
Let me ask you this. On the earlier case that just came out last week, that, and again, I want to thank both parties for their excellent supplemental briefing on a very short period of time, and the fact we had to delay arguments, or we did delay arguments to give you a chance to digest that. So we're grateful for that, for both parties. In the case as it relates to the Board of Transportation, which upheld the governor's authority in that area, the Secretary of Transportation is a cabinet officer, correct?
That is correct.
Not an elected member of the Council of State.
That is correct.
Is there a distinction between appointment powers by members of the Council of State, and I'm referring specifically to Judge Murray's concurrence in the Stein versus Berger case that talked about the difference between our federal system of a unitary executive and the state system of the Council of State being the executive branch? Take it from there. I think you see my question.
I see your point, Judge Tyson. It has never been the governor's position that North Carolina has a unitary executive. That's an accusation leveled at us in our briefing. We recognize the plural executive, and we recognize that the executive branch must have control over the execution of law. And so when it comes to Council of State members, there is absolutely, as a general constitutional matter, it would be perfectly permissible to assign authorities to them that fall within their constitutional role. The people elect a commissioner of agriculture to deal with matters of agricultural policy.
And that includes building codes?
We'll see, and that's where you get into the difficulty. And the difficulty here, to give a very apt example, the Utilities Commission, which is before the court right now.
Well, for example, the Commissioner of Insurance is the state fire marshal and also has the building code, the chief building inspector within his ambit of authority, correct?
Correct. And unusually, if the General Assembly is following what the constitutional role of that office is, and here the Constitution, unlike Article 4, it's not very specific. It just says Council of State members shall have duties as assigned by law, with specific Council of State members, the Superintendent of Public Instruction, Lieutenant Governor, the Treasurer. There are some specific provisions that address them. But otherwise, it's left to the legislature. And so the constitutional separation of powers problem comes from the fact, functionally, the legislature has a lot of control over those council state members. And so,
Where they write the checks.
well, they not just the power of the purse, they could remove, if the treasurer's appointee to the Utilities Commission does not execute the law in the way the legislature wants, they can pull that lever of appointment power, not presenting, passing a statute. That's what the legislature's traditional governmental role is. Their plenary power is the plenary power to make the law.
And including the power of impeachment for all of us.
Right, including the power of impeachment, yes. So, and they have checks, and that, but I would point out, that's a check and a balance. That's not within the legislative power. Mr. Worf, a few moments ago, brought up the idea from McCrory that the legislature can appoint statutory officers in North Carolina. This is, to Judge Murray's concurrence, this is a difference between the federal Constitution and its appointments clause and what North Carolina provides. But Chief Justice Martin, I think correctly, it is a good analysis in McCrory, not that he needs me to say that, but he says, yes, the legislature can appoint members of statutory boards and commissions. That's fine. But it cannot appoint them in all circumstances. So the kind of key piece of McCrory right near the end is 647 in the North Carolina Reporter. When legislatively appointed officers form a majority on a commission that has the final say on how to execute the laws, the General Assembly, not the governor, can exert most of the control over the executive policy that is implemented in any area of the law that the commission regulates. As a result, the governor cannot take care that the laws are faithfully executed in that area. The separation of powers clause plainly and clearly does not allow the General Assembly to take this much control over the execution of the laws from the governor and lodge it within itself. Now, you'll notice in our briefing in this case and in our supplemental briefing, spend some time with that, we're very careful to talk about the executive branch. And the reason we say that, in addition to or governor in the executive branch, because what we're talking about is legislative control of the execution of laws, what's sometimes called a Wallace violation. Here with the Utilities Commission, the fact that the treasurer's appointment is indirectly subject to their control means the legislature, not the executive branch, controls the execution of laws.
Explain that, because the appointment comes from the treasurer, correct?
The appointment comes from the treasurer, but the three levers of control identified in McCrory and his progeny: appointment, supervision, removal. The appointment power is not unfettered. It's subject to legislative confirmation. There is no removal power for the treasurer. So in terms of supervision, removal power, it's something that comes out, I think Cooper confirmation probably explains it the most, but the idea that you can remove someone at will when you pick up the phone or you otherwise talk to them about priorities, what are we trying to do here in terms of what the people elected the members of the executive branch to do, they pay attention when you can remove them. But here the treasurer doesn't have that type of control. If you're the treasurer, the appointee of the treasurer's appointee, you're going to look to the legislature and whatever you can read from its indications, public and otherwise, as to how you should approach your work.
Is that unique just to that single appointment, or is that true of all the members of the commission?
It's the governor's appointees are subject to the confirmation by the General Assembly, and there is limited removal power. And
so what's the difference between the governor's appointees to the commission and the treasurer's appointees to the commission?
If the trial court, if this session law is violated, we return to the governor has 3 appointees. So to the extent executive policy is being made by what the Utilities Commission does, It reflects the executive policy that the governor was elected to implement, not what the legislature wants. And that gets to,
Again, my question is this: is the manner in which the treasurer's appointee treated any different from any other member?
the treasurer's appointee can be changed under the arguments in this case. That could become the Commissioner of Agriculture or the Superintendent of Public Instruction or anyone else.
Any member of the executive branch, Council of State.
Based on the arguments in the brief, I think it could be any constitutional officer. It could be the Chief Justice. It could be a legislative officer, based on how they talk about that power of appointment. So the functional analysis is that this appointee, this treasurer appointee, is effectively the legislature. The last thing I'll say is, in terms of elections, the people elected the treasurer to perform the functions of a treasurer, to manage the public fisc, to manage state investments, the state health plan, and the like. After that election occurred, the powers and duties were shuffled around in Senate Bill 382. So we're not respecting what the electorate elected the treasurer to do and what the people want. So with the gracious 10 minutes of extra time, we would ask that you reverse the trial court on the Utilities Commission and, if possible, the Building Code Council, and affirm as to judicial vacancies. Thank you.
Thank you, Mr. Smith. Any questions? Any questions? Good morning.
Good morning. May it please the court. Craig Schauer. I have the pleasure of representing the Treasurer, Brad Bryant. I want to open with my friend from the other side's opening comment that the governor recognizes the plural executive. That was made after the governor said that the governor's council said that the governor is the executive power and that he has the duty to fulfill and execute the laws. The truth is that the executive power is plural, and the duty, the take care clause to fulfill the laws, is plural. Here, what we have is we have a commission where the majority of the appointees come from the executive branch, which all the council member of state have a shared duty to execute the laws faithfully. Because the treasurer shares the majority of appointments with the governor, the take care clause is being complied with. I want to focus more next, if there's no questions on that point, on the governor's argument that the General Assembly somehow controls the Utilities Commission because the General Assembly possesses the ability to move the appointment power.
Well, that's the question I asked. And is the treasurer's appointee to the Utilities Commission treated any differently than the governor's appointees to the Utilities Commission?
That's a great question, and the answer is no. The governor's argument is that the treasurer essentially is a puppet of the General Assembly because the General Assembly has the ability to move the appointment of power to another council of state member if the treasurer were to appoint someone that the General Assembly doesn't like. Well, the General Assembly has the exact same power over the governor. If the General Assembly doesn't like the person that the governor appoints next to the Utilities Commission, they could reassign that power to another council of state member. So in other words, the treasurer and the governor are indistinguishable under that test.
Under the Stein versus Berger recent opinion, the 15th, this court unanimously agreed that the legislative control of the Board of Transportation was unconstitutional. Why is that not applicable to the Utilities Commission?
Your Honor, to be frank, I did not study the Board of Transportation as closely as I did the three, I think, more analogous commissions, where you had the three commissions that are housed in DEQ. In other words, they are administrative commissions housed in an executive agency that's considered a cabinet agency, where the governor had majority control. And then what happens is the General Assembly changed control from the governor to taking one of the appointments and giving it to another member of the executive branch, either the Commissioner of Agriculture or the Commissioner of Insurance. And the court said because the executive branch maintains majority appointment power, there is no constitutional violation. I think that those three instances where the appointment power was moved from the governor to being shared between the governor and another member of the Council of State are indistinguishable from this case.
So you're looking more at the quasi-judicial independent nature of the commission as opposed to being a member of the governor's cabinet? Would that be the distinguishing factor?
You know, in terms of the appointment power, the fact that it's a quasi-judicial committee, I don't think that's really a relevant factor. I think when I read the boarding commission decision from this court 2 weeks ago, it really focused on essentially a head count. In order for the executive branch to maintain control, it took a look at who appoints the majority of the members of these commissions. Because the majority of the members were appointed by the executive branch, that seemed to be the conclusion of the analysis, because the executive branch maintained control, which consistent with the interpretation of the take care clause, which is a non-exclusive duty shared by all council of state members.
Can the General Assembly change the appointment power from the treasurer to somebody else
Yeah, it absolutely can.
at any time?
I think it can at any time for
Okay.
2 reasons.
So if you have 2 appointments for the governor, and you have the legislature who can change the appointment to anybody else at any time, and the legislature who can remove the appointment from that appointee at any time, is that correct? It's the legislature can remove whoever the treasurer appoints, is that what you said to me?
So I thought the question was whether or not they could change the
Yeah,
appointment power
so
at any
they
time.
can. So they can change who does the appointing, right?
Yes.
So what happens to the candidate who is appointed? Can the legislature remove them?
In this,
Who has the opportunity to remove them from the Utilities Commission, the person who's appointed to the board?
so in terms of the Utilities Commission, I just want to make sure I understand your question, Madam. Can the General Assembly remove the person who's appointed by the treasurer
Correct.
to the Utilities Commission?
Yes.
Under the impeachment standard, I believe that's applicable to all commission appointees. So yes,
Okay.
they have the ability to remove.
So they have the removal power?
Well, limited by the confines of what would be necessary to find somebody impeachable.
Okay. I guess my question is, if the General Assembly can choose the treasurer and the General Assembly can also remove who the treasurer appointed, is that power really the General Assembly's? So do you really have a majority power in the executive branch?
Well, I believe the removability provision applies to
Everybody?
everybody.
Mhm.
So this would be it also applies to the governor's appointees.
Okay.
And I believe that it is not legislative control because the legislature doesn't dictate who sits on the Utilities Commission. Plus, they don't have unfettered discretion on removing somebody. It's subject to the impeachment standard, which is a pretty high threshold. I mean, to say that the ability to remove somebody for an impeachable reason gives the General Assembly control over that body would threaten the independence of the judiciary, because that's the exact same standard that applies to all the judges in the judiciary. So I don't think the removability power limited by impeachment is an encroachment of the General Assembly on the Utilities Commission.
Okay.
What I'd like to
Now, I want to make sure I'm clear on this. So basically, you're saying that the treasurer's appointee is treated no differently, or the legislature exercises no greater control over that appointee than any other member of the commission. Is that correct?
Well, any other appointee from the Council of State. I think we'd have to concede that the General Assembly has greater control over its 2 appointees that it itself can choose. But yes, I don't think you can distinguish the appointments made by the General Assembly and the treasurer because they're subject to the same conditions. But I'd like to point out that the argument that the General Assembly is making in terms of control is that they're saying that the General Assembly can control the Utilities Commission because they have the ability to influence who the treasurer is going to pick. Because if the treasurer doesn't pick the right person, they can change the appointment power. In other words, they have the ability to I think they say, make the choice for the treasurer is the language they use in the brief. You know,
Are
what they
these
don't
appointed,
challenge-
aren't these folks appointed for a term of office?
I believe it is a term of office. I don't know the length, but it is a defined term. But what I think they're overlooking is that they're not challenging provision in the statute that says that any appointee by the treasurer and the governor must be subject to confirmation by the General Assembly, which means that the treasurer can name person after person. Until the General Assembly approves that person will not take the seat. In other words, the General Assembly already has the ability to influence who the treasurer and the governor are going to pick through the confirmation power, and that's not considered an overreach of the General Assembly. Just because they have the power to do it through the ability to remove or change the reassignment power, in the end, it's still the same exertion of control over the Utilities Commission, which is the ability to influence the pick. That ability pre-exists with the confirmation power, which is not unconstitutional, which means I don't think there's really much merit to the argument that the General Assembly really has control of the Utilities Commission simply by the ability to reassign. Judge Collins, you made a point about whether or not they can change the assignment at any time, and I believe they can for 2 reasons. Their argument that you can't change an assignment after an election would essentially be a complete bar on ever changing a Council of State member's powers, because anytime you change a Council of State member's powers, it's going to be after an election, whether it's 1 month, 1 year, 3 years. They were elected for a certain purpose. The General Assembly is going to change their powers. Under their argument, there would be a complete bar. There's a second reason, if I could have a brief extension of time. The second reason slipped my mind.
I gave you time and nothing.
Watching the clock made me drop the second reason. I think my first reason is sufficient. With that, we would ask the court to affirm the decision below regarding the Utilities Commission, if there are no further questions from the bench.
I have one further question. I'll direct it to both counsel. There is a procedure that appeals from the Utilities Commission go directly to the Supreme Court and not to this court. Is there a question of jurisdiction here over this matter with this court?
I'm sorry, appeals regarding the Utilities Commission going straight. Your Honor, I don't believe so for two reasons. I believe that is those are decisions by the Utilities Commission in terms of where they go. This is not a decision by the Utilities Commission. This is a decision regarding the appointment power of the Utilities Commission. And I also believe that only certain decisions by the Utilities Commission go straight to the Supreme Court. I think it's rate-making decisions. I think other decisions by the Utilities Commission would actually properly come before this court for a lot of reasons.
Thank you. Yes.
Mr. Shower has it correct that the general rate making are what go to the North Carolina Supreme Court. There are, I can't remember what they're called, but they do come to this court. But this is a question about the constitutionality of a statute rather than a matter that actually originated with the Utilities Commission. So there is no proceeding below originating from the Utilities Commission. And so I would concur with Mr. Shower that I don't perceive a jurisdictional question. And I see Mr. Wharf nodding, and he's a jurisdictional expert.
Thank you very much. Any other questions?
No, I don't.
We would like to thank counsel for the excellent arguments. Again, we'd like to thank counsel for the supplemental briefing that you did on very short notice. And if there are no further matters to come before the court, the case is submitted and we will stand adjourned.
All rise. This session of the North Carolina Court of Appeals is adjourned.
Got my name in the record. What's this more case you keep pulling out?